What are patents? Patents protect technical features of an invention. So any form of creativity that involves a technical character and some kind of a technical effect would usually be governed by laws of patents, because patents then protect technical embodiments of inventions. Similarly, what are copyrights? They basically have to do with authors' work. Authors, they can come up with writings as their expression, music, film, other forms of artistic creativity involving photography. So these are all kind of works that would be usually protected. Introduces or sells the product in the market as if the product is coming from a different source while not identifying himself with the product. This kind of action and remedy against such kind of violation is a remedy involving passing off. Now, unfair competition may also be used as principles for preventing fraudulent, deceptive or dishonest trade practices prohibited by a statute, regulation and common law. So what is the underlying philosophy or the concept involving intellectual property protection? So basically you want to protect certain forms of innovation and creativity, either to provide incentives against market failure, because the more and more one comes up with invention, and if they are allowed to be free rided, then the person will not have an incentive to produce further. So there is market failure in innovation and creativity. And there are other kinds of issues that you want to resolve in the market, basically that relate to information asymmetry, wherein you want to protect the consumers against deceptive practices, because people may use marks that do not belong to them and may create confusion in the market, and that can be harmful for consumers. So there are both kinds of aspects that involve the underlying philosophy. One is to prevent market failure in innovation and creativity, and second to resolve information asymmetries. But common to both these is the principle of differentiation. Intellectual property protection primarily has to deal with how differentiated goods and services, by virtue of innovation, creativity, or by virtue of creation of a goodwill in the market through projection of their marks, how can these products be differentiated, and how can law provide protection to differentiate it in actual markets. Now, what is the difference between real property and intellectual property? In our previous discussion, we saw that the primary concepts involving property right, that is exclusion and alienability, has its roots in the property based system as in real property, and that is why most of the concepts that you encounter in intellectual property have to deal with real property. However, there are many distinguishing features involving both property rights and intellectual property, and I would relate some of them here. Unlike in case of land or in case of products as in chattels, intellectual property is easily replicable, in the sense that the marginal cost of producing one additional product involving intellectual property is much easier when compared to physical forms of property or real property as in land and chattels. It is easily replicable, and this is classically because of what is called as the public good character. We will discuss more of these public good characteristics in our class on economics to intellectual property, but suffice it to mention here that public good has two important characteristics of non-rivalry and non-excludability. Unlike in case of land and chattels, consumption of knowledge by so many people at one point of time does not diminish the possibility of each other to consume the same piece of knowledge. Similarly, information once out without any adequate protection, it remains with the person who has got it. So once the information is given, it cannot be dispossessed from that person. So it is non-excludable and non-rival in character, and it has important implications of how we understand the economic differences between property and intellectual property. Second, intellectual property can be generally classified as negative rights when compared to the real property which are usually determined as positive rights. So in intellectual property, it is not so much about the use of those rights positively, but it has to do with excluding third parties from using, making, selling, or any of the specific rights that are granted to you. Now, what are the real implications of having it mentioned as a negative right? So, if you have an intellectual property right, either patent or a copyright or a design, you cannot claim that by virtue of this you have a right to market the product. The marketing and the actual regulations that pertain to safety or other characteristics will be decided by an external law. Intellectual property only allows you to exclude others from actually copying the invention or copying aspects of your creativity. So, they are negative in that sense, so that you do not make any kind of positive claims towards marketing or towards positive use of the product. That right is not provided by intellectual property law. Third is the term limitation. In most categories of IPR, patents, copyrights, industrial designs, they are limited by time duration. The reason is because society wants to create a balance between some kind of a monopoly type of protection or an exclusivity protection that is offered to intellectual property right holders vis-a-vis the societal need that the invention should be part of the public domain and more people should be able to access it. That is why the term duration for patents is limited to 20 years. For copyright in India it is life plus 60 years, and for industrial designs it may vary from country to country from 10 to 15 or 20 years. So, it is specific in time. However, certain other forms of intellectual property like trademarks and geographical indications can be renewed in perpetuity. It means once you file a trademark application, you will be given a certain specific period of time for protection, and after that, until you are in business and you want to continue with the business, you can keep on renewing the marks, both in case of geographical indications and trademarks. The reason why both these forms of protection allow you renewing in perpetuity is because if you would keep it bound by time duration and if it falls in the public domain, naturally many people would use that mark, usurp that goodwill and create confusion in the market and can ultimately hurt consumers. So, to prevent consumers from being deceived, the time duration that is provided in trademarks and geographical indications is unlimited in terms of protection. Trade secret protection can also be unlimited or in perpetuity for the reason that by virtue of secrecy you can protect it as long as you have made sufficient or taken reasonable measures to protect it for that period of time. So, until you yourself lose the secrecy or someone else misappropriates it, you still have the right in keeping that kind of confidential information in perpetuity. The acquisition of intellectual property is specifically created by the statute. So, there are acquisition procedures involving trademarks, geographical indications, patents, industrial designs and all other forms of intellectual property except copyright, where registration may not be required. The reason is copyright has this principle of automatic protection, which means registration only becomes voluntary and not mandatory. Similarly, trade secret protection, if it is provided through common law or even if provided through certain statute, may not require specific registration. Intellectual property distinguishes itself from other forms of property in terms of its public notice function, and this public notice function is important for third parties. For example, in case of land, by virtue of a boundary or a compound wall, the landholder is able to sufficiently give public notice to the society of what the actual boundaries of the land are. Or in terms of a physical chattel, a good like a pen, a pencil, you actually know that these are the confines of the product. But in case of intellectual property, since the underlying protection is for information and knowledge, how it can become difficult to actually create boundaries. For example, in case of patents, claims define the actual boundaries. Patent claims define the actual boundaries of the patent, and since patent claims are drafted in languages that are known to all of us, and the interpretation of languages can be distinct. The boundaries of the patent are usually fuzzy. So, these fuzzy boundaries are because of different understanding of what the domain of knowledge that should be protected. Inventors may have a certain conception of what the claims of the patent are or what the boundaries of the patent are. Once the application is made to the patent office may have certain conceptualization of what the claims are, and furthermore third parties, external third parties will have a certain version of what the claims are or how the claims must be interpreted. Finally, when litigation ensues in the court will apply certain doctrines involving claim construction or patent claim construction, and they will come to a certain conclusion of what the boundaries of the patent are. So, ultimately from the conceptualization by the inventor till the conflict is specifically resolved by the court, the boundaries remain fuzzy, and this is very unique to patent law, unlike in case of landed property where there might not be much of an argument over whether the landed boundary specifically allows the public a kind of a notice regarding the exact boundaries. There can also be certain specific conditions on the grant of intellectual property. So, even before you grant intellectual property rights, they may be subjected to conditions which you cannot refuse post grant. For example, intellectual property rights in the case of patents are subject to research exemption, or also called they may also be subjected to Bolar exceptions, or also called as regulatory review exceptions. Copyright may be subjected to fair use, and also in case of trademarks, marks can be subjected to honest and concurrent use. Courts also determine the boundaries of intellectual property. So, even if a property right is validly granted, for example a patent has been granted, it does not ultimately mean that the particular boundary of the patent is clear. It can be negotiated and renegotiated in litigation, and sometimes external laws like competition law can actually determine to some extent the type of use or whether it amounts to abuse of monopoly. So, in some sense there can be laws that require you to limit your monopoly. So, that is very unique to intellectual property law in the sense that application of external laws can also influence the amount of monopoly or market power that you can hold. Similarly, court can also tailor the boundaries of IP in the sense that, for example, since copyright does not require registration and that registration is voluntary in copyright, the question of the threshold requirement of originality, which is required for all kinds of works involving copyright, will ultimately be decided in a litigation by a court of law. So, until then copyright requires very basic minimum level of creativity, which is called as the criteria of originality, which only when challenged in the court of law can be conclusively determined. So, courts can often actually tailor the requirements of monopoly and also tailor the boundaries of intellectual property. Injunction and other remedies are provided as much as in case of any property right, and preliminary injunctions may not be sometimes easily granted in case of patents, because in case of patents determining ex ante the claims and the technical arguments involved may lead to an extensive trial, and if that has to be avoided, then the courts must actually look into principles of injunction, which is usually called as the 4-factor test, and try and decide whether in certain cases a remedy in the form of an injunction should be given or not. However, in case of trademarks, a remedy in the form of an preliminary injunction may be easily handed out, because there are certain effects that relates to consumer deception. Finally, in case of property rights, restitution is usually allowed. Restitution means that the defendant shall be put in a position of which he actually had at the time when the wrongful action began. But in case of intellectual property, suppose a patent is granted and it is granted by the patent office, and after several years if it is challenged in the court of law and the court of law declares it as an invalid patent, the consumers who lost by giving a price which is in some sense a monopolistic price will be the losers, in the sense that they will never recover the price that they have paid to the patent holder. This is only in cases where the patent is subsequently, or any other IP right is subsequently declared as invalid. For that period of time where there was a presumption of validity and where consumers have already paid for the product, they shall not be restituted.